the inside story on the issues that affect you and your community. This is Local 12 Newsmakers.
After discussing this matter with multiple jurors, both black and white, and they have to a person said to us that we will never get a conviction in this case.
Good morning and welcome to Local 12 Newsmakers. I'm Dan Hurley. After two mistrials because juries have not been able to come to unanimous decisions, Hamilton County prosecutor announced last week that his department would not ask for a third trial in state court. But Mr. Dieters did raise the possibility that the case might move to federal court.
They can introduce evidence of racial prejudice, and we were not permitted to do that in our case. I think there's a much greater likelihood of success for the federal people than us, based on the evidentiary rules we got.
To talk about the issues raised by this case, I'm joined by Gerhardstein, who has a great deal of experience in the federal courts in the area of civil rights litigation. Mr. Gerhardstein is a principal with the firm of Gerhardstein & Branch, which describes itself as being committed to using the law to help those on the margins of power. They specialize in cases involving police brutality, racial profiling, sexual harassment, and discrimination based on race, gender, religion, or sexual orientation. Al, welcome back to Newsmakers.
Well, it's great to be here.
You do work a lot in the federal courts. And one of the things that Joe Dieters was criticized in some areas for by some people was that the charge was wrong, that he insisted that the charge ought to be murder, which involves intentionality and all sorts of things, and that he should have, some people say, lowered the charge, either never having introduced murder or lowered it for the second trial. What do you say about that, and how does that impact any charge in the federal system? And are those the kind of charges that we'd even be talking about in the federal system?
Well, I have represented, along with several other attorneys, the DuBose family through this whole ordeal, starting from days after the shooting. And I can tell you on their behalf that they didn't think that Mr. Tensing was overcharged at all, and I agree with them. I think this case could have been proved as a murder case, as well as the involuntary manslaughter. And we can talk about that, but let me get to the second part of your question, which is now what's on the table in our community. What is it that would move to the federal court? Right. It's not a duplicate of the state charge. Federal courts do not simply do a do-over of state criminal law. The issue in federal court would be, did Ray Tensing violate the civil rights of Sam DuBose? Did he do it under color of law? Did he injure or kill Sam DuBose in the process of that? And did he do it willfully? If those four things can be proved, then a federal conviction can be secured. Now, what are the civil rights involved? Right. Two things. One is, did he violate Sam DuBose's right to be free of unreasonable searches and seizures? That means, did he use excessive force? That's an unreasonable seizure under the law. Secondly, did he violate Sam DuBose's right to be free of race discrimination under the 14th Amendment? Those are the issues that, on behalf of the family, we have certainly pressed the federal government and local U.S. Attorney Ben Glassman to pick up and really thoroughly investigate, hopefully indict, and try Ray Tensing on.
So the murder thing is off, and this would be a criminal case, though, in the federal courts. This is not just the DuBose family suing in a civil case.
The plaintiff is the United States of America.
Okay.
So it is a criminal case. There would be a separate grand jury that would have to indict under this federal civil rights law, and there would be a jury trial if it goes that far and there's no plea, with a jury composed of members of the community that are drawn from the Indiana border all the way to Portsmouth. So it's a very broad area of the state.
Why to Portsmouth?
Well, because it's Scioto County is
it's just where the 6th district
is where the Southern District of Ohio.
Oh, the Southern District of Ohio goes. So it's more broad.
It's
a much broader than Hamilton County.
Oh, absolutely. And in my experience, because I do a lot of work in federal court, unfortunately, it's less likely that there'll be blacks on that federal jury than in Hamilton County, court.
Because you're getting all the collar counties in and the
upriver
counties,
right,
which are
predominantly
much less
white.
Okay. So this question of race that you've just, that would be a civil rights question. It's also a question that Joe Dieter's raised, that race is an important factor in this, and it was, in effect, he was saying that in talking to members of the jury that there was just no way to break through on that. In the backdrop of all the other police brutality cases that have been going on in the last 18 months, 2 years, where there haven't been convictions, do you think it's possible to get a conviction of a police officer, period? I don't, whether there's race involved or not?
Yes, but it's not easy. And we've been working at this, this is my 40th year as an attorney, and I have been litigating police misconduct cases most of that time. So how do you do it? How do you even get a jury to hold an officer liable? Well, the first thing you have to do is acknowledge that race is in our face, okay? During the voir dire, during the presentation, you really need to be able to talk openly about the role of race. And Dieter's was handcuffed. We had the T-shirt. We had UC's own analysis showing that Ray Tensing disparately stopped black people in a way no other officer on the force did. Also showing that Ray Tensing pulled his gun more often during traffic stops than any other officer, always against black people. That never got into evidence.
None of that got into evidence.
None of that got into evidence. And yet, we hear about the marijuana in Sam DeBoe's car. Ray Tensing didn't know anything about that marijuana. What's that doing there?
Did that get into the testimony in the trial, though?
Yeah, it got into the second trial. And we have Ray Tensing showing his 2 traffic stops before he stopped Sam DeBoe's. What's that doing there? If we can talk about those 2, where he allegedly is polite to a couple of black people, then let's talk about the months of over-policing of black people.
The data.
Yes, and the reality, because that data represents real people who were stopped, many of them without a real serious crime.
Was there a way around that? Should that have gotten in, and was there a way to get that in?
Sure, it should have come in because it demonstrated that Ray Tensing had a double standard. That he, when it came to black people, was more likely to pull his gun, was more likely to act in a way that basically viewed them as law violators than as citizens that he was simply there to serve and protect. Now, it didn't get in, and yet other evidence that put Sam on trial, even though he was dead, did get in. That got it totally out of whack, and that's unfortunate. So there's a whole other thing that we do when we try these when we try these police misconduct cases. That is, we have to focus the jury on what a reasonable officer would do. If you go back and look at these...
Reasonable officer, is that a legal term?
Yes, it's definitely a legal term, because under the 4th Amendment, it isn't just about whether the officer on trial believed that his life was at risk. It's whether that officer's belief was reasonable, whether a reasonable officer in the same position as the one on trial would also agree that his life was at risk and would also use deadly force. How do we present that to a jury? Well, we show jurors how officers are trained. They have multiple ways of training officers to act in rapidly evolving situations where they stay focused on objective facts. There's big, what we call FATS machines, giant videos, and a woman comes around a corner, there's something in her hand. The officer has to decide right away whether to shoot, don't shoot. You shoot, it's a baby in her arms, you know, and he just shot a baby. And then you do it over and over again. That's in the academy, that's during in-services. It's called shoot, don't shoot training. They do it in real life in the field. They do it when they're clearing buildings. They're constantly trained how to use their judgment in these rapidly evolving situations. In the Tensing trial, during closing arguments, appeals were being made to what you would do if you were in that situation.
You mean
to the
one
jury.
of the jurors?
Yeah. Well, this isn't about what a juror would do. They didn't go through all that training. This is about what a reasonable officer would do. And that's what we focus on so much when we try these cases. That's what has to be done. We have to get the jurors to shift from their own, but for the grace of God go I view, to what would a reasonable officer do. And that's tough. I mean, that takes putting on experts about training and so on.
Does that make any difference whether that's in state court or federal court?
That particular issue should be presented in both forums, because in federal court, the one constitutional violation is excessive force. And it's, unless you understand how to measure excessive force and how to hold an officer accountable, then you won't be able to do the job.
Therefore, what's reasonable?
That's right.
Based on training.
Right.
So, okay. That doesn't necessarily have anything to do with race.
No, that is totally independent of race. But if you are naturally more uncomfortable around black people, if you have a bias that makes you more likely to pull your gun with black people, you have to name that, you have to own it, you have to train your way out of it so you don't shoot people just because they're black. Mm-hmm. And that's tough stuff. You got to work on that.
People are talking, Joe Dieter says that he has talked to the federal prosecutor for Southern Ohio. What is the ability, who makes that decision? Does the local prosecutor for Southern Ohio, federal prosecutor for Southern Ohio make? I'm thinking about now that this is talking about federal court, and given that Jeff Sessions is the head of the Justice Department and President Trump, and they've made it pretty clear what they think about a whole number of things in this area. Who really makes that decision? Does the local prosecutor really have the ability to take this case?
The local U.S. attorney, Ben Glassman, is a major player in that decision, but does not make it alone. He consults with the Civil Rights Division of the Justice Department. And that Civil Rights Division has, since Jeff Sessions has been Attorney General, has convicted a police officer of using excessive force in South Carolina, Michael Slagle. When Mr. Scott was shot by Michael Slagle, he was first charged, Slagle was first charged in state court, hung jury, and then he was federally charged and indicted. And just, a month ago, he pled guilty to a federal civil rights violation. So that's on Trump's watch, that's on Jeff Sessions' watch. That gives me some hope that when you have the facts, you have the law, that justice can even be done these days. And it's always been hard to get a federal civil rights prosecution. The officers that were involved in beating Rodney King went through this. They were acquitted at the state level. They were charged and convicted then for several federal civil rights violations. But when Michael Brown was shot in Ferguson, Civil Rights Division did a very thorough investigation, and they concluded they wouldn't even present it to a grand jury. And of course, Tamir Rice, Eric Garner, they did not result. And now we just had John Crawford. None of those have resulted in any federal civil rights prosecutions.
So nothing's automatic.
That's absolutely sure. And all I can say is we've seen both results since Trump has been president. And I'm hopeful that if we present the right evidence, that they'll be open to doing the right thing. Because let's remember where this all came from. I mean, right after the Civil War, The North is in Reconstruction. They are occupying the South. They are enforcing the law, and local lawmakers had to step aside. And then very quickly, the North withdrew, and sheriffs are witnessing lynchings. Sheriffs are participating in outrageous acts of violence against black people, and Congress responds with the Reconstruction-era Civil Rights Acts, which include a criminal provision, because the federal government is a whole independent system of government. And when state officials don't do their job and don't protect an entire group of U.S. citizens, then the Civil Rights Act, that's why it was written. So here we have Sam DuBose, black, unable to be, Ray Tensing unable to be convicted because of, partly as admitted by the prosecutor, partly because of the race involved. This is just the kind of situation that this statute was made for.
And that civil rights statute is still in force.
Yes.
Yeah,
it was not used much because remember I said under color of law? Mm-hmm. Well, he's a police officer. He clearly acted under color of law. We had 100 years when suddenly the court started saying, well, if he violated his rules as a police officer, he's no longer acting under color of law. It was only in 1960 when the U.S. Supreme Court said, no, we're getting this wrong. He's acting with the power that he has as a police officer, that even if he's violating all the rules, therefore he's still acting under color of law.
Yeah. I would love to get into one other area, but I'm out of time, but we're going to have you back at some point because I want to talk to you about what's this whole experience tell us about juries? What can or should we be doing with the future of juries? So thank you very much for being here. And
glad to be here.
Baseball has always been more than a sport. It's been a channel for immigrants and minorities to chase their dreams and become Americans. After the break, a new exhibit with an interesting twist on an old story. Stay tuned. Welcome back. Almost everybody and every American knows the broad outlines of the Jackie Robinson story. When he broke into the major leagues in 1947 with the Brooklyn Dodgers and promptly became the Rookie of the Year, it was about more than just one more talented baseball player fulfilling his dreams. It was about broadening access to the American dream. A new exhibit at the Skirball Museum on the campus of Hebrew Union College, entitled Chasing Dreams, Baseball and Becoming American, takes that underlying story and explores how it played out for many minorities. The exhibit, which opens on July 30th, explores the way baseball and national identity weave together with the story of the American Jewish immigration. To discuss this exhibit, I am joined by the director of the Skirball Museum on the campus of Hebrew Union, Abby Schwartz. Just to be clear, Abby grew up in a family of die-hard Yankee fans. Since moving to Cincinnati, she has tried hard to acculturate to the world of the Cincinnati Reds, which, after all, became the first all-professional baseball team in 1869. The Yankees, I want to point out, Abby, can sort of trace their roots only to 1901 in Baltimore, but don't become the major league team and call themselves the New York Yankees until 1913. Correct. They are basically upstarts.
Exactly. And you did your homework.
I did my homework. Once I saw that, it was just like too much fun not to.
Well, what can I say? My son is now a Mets fan, so he and my mother really got into it in the last years of her life. So.
Yeah, I know she did. So anyway, there is this long tradition of immigrants of different backgrounds playing baseball and using baseball as a way to get into American society, and that's really what you're exploring here with the twist and a focus on Jewish players.
Yes,
right?
That's exactly right. And in the early years, everybody was an immigrant. You know, I mean, we have a great picture of in this show of Hank Greenberg and Joe DiMaggio. I mean, Joe was an Italian immigrant. Hank was an American Jew. Yeah. So there were all these immigrant groups really came into the game at the same time, and in those early years there wasn't so much discrimination. You know, it was, especially in the 19th century, I mean, it wasn't even really much of an issue because everybody was part of that melting pot. But it is an interesting story where we really have that ability to talk about the relationship between immigration, not only for the players but for the fans and for the children, and how this was a great equalizer, great leveler.
Everybody could share the same stories.
Exactly.
Share the same passions.
Yes, and I think what we're finding when we talk about it, and when we look at these artifacts that we've augmented this pop-up exhibition with, is that everybody has a memory. Everybody has a flash of some baseball memory from their childhood, whether it was on the Little League field or professional ball or high school. So it's really kind of fun.
One of the photos that I presume is in the exhibit is, but maybe this is something you augmented the exhibit with, is Rudolph Kalish, who wasn't a professional player, but he played for the Cincinnati Live Oaks.
That's correct.
In 1870.
Right.
Basically at the same time the Reds are being. There were a lot of baseball teams. It's just that the Reds were the first one to have all professional players.
Correct. To be called a major league team. Exactly. So yes, this was pretty much the uniform with that sort of Gothic C. Well, that's the
Live Oaks.
The Live Oaks, the Gothic L, and the Cincinnati Reds had the Gothic C on. Otherwise, sort of just, you know.
And I understand that Lip Pike, L-I-P,
yes.
Lip Pike, who I don't have a photo of,
yeah,
right?
yeah,
was the first Jewish major league player.
That's correct. I think you do have a photo of the 1886 record. Okay, I think it might be in the feed. But anyway,
he also has a Reds connection.
He does. He was the first major league player playing for the Reds starting in 1877. First Jewish player. Played for the Reds for about a year. He'd played for other teams before that. But he was the first. He hit the first Reds over the fence home run.
At a time when getting a ball out of the park
was
almost unheard of.
Big deal. Yeah, he ran a race against a horse and won. He was really fast, and he was really handsome, and he had this huge head of dark wavy hair and a really prominent mustache, and his image is, of course, not in photographs but in in print. And we're actually doing a limited edition bobblehead of Lipman Pike. That'll be a gift with a modest donation to the
another bobblehead for the collection. There you go.
The collection,
you were talking about Hank Greenberg, and that's probably the person of Jewish background that more people would have heard of than others.
Yes.
And talk a little about Greenberg.
You know, Greenberg was. He came in right around the same time as Joe DiMaggio, and he was a real gentleman, and he, of course, left, like Joe, to serve in the military.
But we're talking late 30s, early 40s.
Yes, I think this photograph is from the 40s.
Here's with Joe DiMaggio.
Yes, and they had a commonality in terms of their status as outsiders. And of course Hank Greenberg is known for not playing ball on Yom Kippur and being able to, say that he was not going to do that, and it really sort of awakened people to some of the issues around ethnicity and being honoring your religious commitments. He did say, I think it was interesting, that after the war people stopped talking about a Jewish player or an Italian player after the Second World War, when these guys both served, and it's sort of the tone changed. And
it's not only the players, and I want to make sure I get this one in. There's some sheet music for "Take Me Out to the Ball Game," so it's things that have become part of the American. There we go.
Yes.
And how's this connected?
Well, the person who, not the lyrics, but the composer for the piece for this song is a man named Van Tilzer. He was Jewish. Okay. Never went to a ballpark.
Never went to a ballpark.
No. Wrote a song that is the third best known song in American music. Guess what the first is? Happy Birthday.
Oh, happy birthday, yes.
Second is the Star Spangled Banner, and the third most remembered music is Take Me Out to the Ball Game.
Well, I want to make sure people know how to find this. Chasing Dreams, Baseball and Becoming American is housed at the Skirball Museum on the campus of Hebrew Union College, Jewish Institute of Religion in Clifton. It opens, opening day, is Sunday, July the 30th and runs through October the 22nd. On opening day at 2 o'clock, Reds historian Greg Rhodes will talk about the Reds and the immigrant experience. And to learn more about this exhibit, you can just search for Skirball Museum Cincinnati, and it's all right there. Thank you, Abby.
Thank you, Dan.
Good luck with this.
My pleasure.
Thank you for making Newsmakers part of your Sunday morning. Have a good week, and we'll see you next week.